Welcome to This Explainer. As a senior EHS manager, I've seen firsthand what happens when workplace safety and legal compliance collide. So today, we're jumping right into a high-stakes discussion about the critical protections that keep our industries running safely. We're unpacking OSHA whistleblower protection, and specifically, we're going to focus on your rights under 29 CFR, Part 24. Okay, picture this. It's a scenario that literally keeps safety professionals awake at night. A frontline worker spots a routine $50 hazard. Maybe it's a frayed wire or a busted guardrail, but management ignores the report. Even worse, the worker is wrongfully disciplined or just outright fired for speaking up. Well, guess what? Because of the fear of retaliation and the legal fallout that comes with it, that $50 fix can rapidly escalate into a $500,000 retaliation lawsuit. The financial and operational consequences of an unreported hazard and a retaliatory culture can absolutely devastate a company.
All right, let's get into Section 1, the hidden shield. This is our introduction to 29 CFR Part 24.
So why do we call 29 CFR Part 24 a hidden shield? Well, it actually establishes the procedures for handling retaliation complaints across 7 major high-impact federal laws. It's a shield that fiercely protects workers from retaliation when they raise safety concerns, while at the same time safeguarding a company's bottom line from the catastrophic fallout of unreported hazards. We're talking about 6 major environmental statutes here, things like the Clean Air Act and the Safe Drinking Water Act, plus the Energy Reorganization Act of 1974, which covers the nuclear sector. If you're reporting a violation under any of these specific acts, 29 CFR Part 24 is basically the procedural playbook for your whistleblower rights.
But before we go any deeper, we really need to define the baseline here. What is the actual difference between whistleblowing and retaliation? Whistleblowing in this context is simply the protected reporting of hazards or violations. It's an employee doing exactly what the law encourages them to do. Retaliation, on the flip side, is an employer's unlawful adverse action taken against that employee precisely because they blew the whistle.
Moving right along to Section 2, Prohibited Acts and Protections. Let's take a look inside Section 24.102.
You might be wondering, what exactly constitutes a protected activity? When is a worker officially shielded by this law? Well, if we look at the official investigator's desk aid, we see a really broad scope of protected activities. It is not just about calling a whistleblower hotline. Protected activity includes filing safety or health complaints with OSHA or your management, instituting proceedings, or providing testimony. It even covers exercising rights like refusing to perform a dangerous assigned task under certain circumstances, or just requesting information from OSHA. The whole idea here is that the law covers a wide array of actions to make sure workers feel genuinely empowered to raise concerns. Now, the protection is broad, but there's a crucial caveat here that most workers, and honestly, even a lot of supervisors, don't know. Protection also covers employees who are merely perceived as having engaged in protected activity, even if they actually didn't. And get this, it also protects you if you were simply associated with someone who engaged in protected activity. So if a manager fires you just because your work best friend called the EPA, yeah, that is still unlawful retaliation against you. To make this completely crystal clear, let's contrast the two sides. On the left, we've got the protected activities, engaging in proper hazard communication, safety reporting, or testifying in a proceeding. On the right, we have the prohibited employer actions. The law strictly forbids employers from intimidating, threatening, restraining, coercing, or blacklisting an employee. It prohibits firing, demoting, cutting hours, or even reassigning an employee to a totally undesirable shift just because they engaged in a protected activity. Let's move to Section 3, the burden of proof. How do you actually win the case? So how does OSHA actually evaluate who's right? When an employee files a complaint, an employer will almost always come back and claim, oh, the worker was fired for poor performance, not whistleblowing. And this brings us to 2 incredibly important legal concepts, contributing factor and temporal proximity. Under these statutes, an employee doesn't have to prove that retaliation was the only reason they were fired. They just have to show their protected activity was a contributing factor, meaning it affected the employer's decision in some way. And then there's temporal proximity, which is the close timing between a safety report and a disciplinary action. That timing alone can automatically raise an inference of retaliation. I mean, if you report a chemical spill at 9 a.m. and get laid off at 10 a.m., that close timing speaks volumes to an OSHA investigator. And this brilliantly illustrates the burden-shifting framework of 29 CFR Part 24. Once the employee meets that lower contributing factor standard, the burden shifts entirely onto the employer's shoulders. To escape liability, the employer must prove by clear and convincing evidence that they would have taken the exact same adverse action even if the employee hadn't blown the whistle. And let me tell you, that is a much heavier burden of proof placed on the company.
Just to emphasize how strong this protection really is, take a look at this recent landmark Supreme Court decision in Murray v. UBS Securities. The court explicitly stated that this burden-shifting framework is literally meant to be plaintiff-friendly. Whistleblowers do not need to prove employer hostility or animus. They simply need to prove that their protected activity helped cause the adverse action. This makes 29 CFR Part 24 an incredibly potent tool for EHS compliance.
Okay, Section 4, the investigation process. Let's look at sections 24.104 and 24.105.
Let's dive into exactly what happens when a worker pulls the trigger and an official investigation kicks off. Here's the procedural timeline mapped out for you. First, the investigating office receives the complaint. OSHA then notifies the respondent, the employer, about the filing. The employer is then given 20 days to submit a written position statement defending their actions. From there, the OSHA investigator steps in as a neutral fact finder, collecting evidence from both sides. Finally, the Assistant Secretary issues written findings on whether there's reasonable cause to believe retaliation actually occurred.
Now, what's really fascinating here is a super powerful remedy called preliminary reinstatement. If the OSHA investigation finds reasonable cause to believe retaliation occurred, they don't have to wait for a years-long court battle to play out. Under these regulations, OSHA can issue a preliminary order requiring the employer to immediately reinstate the worker to their former position with back pay while the litigation continues. That's right, you can get your job back before the case even ends.
On to Section 5. Deadlines and actionable steps. And listen up because the clock is definitely ticking. As an EHS professional, I absolutely cannot stress this warning enough. All of these incredible legal protections completely vanish if you fail to meet the strict legal deadlines. If you're reporting under the 6th environmental statutes, like the Clean Air Act or the Federal Water Pollution Control Act, you have a rapid, incredibly tight window of just 30 days from the moment the retaliatory decision is made and communicated to you. 30 days. For the Energy Reorganization Act, you have 180 days. Miss these deadlines, and your OSHA retaliation complaint will simply be dismissed. So, what's your actionable takeaway from this explainer today? Whether you're a frontline supervisor or a worker on the floor, here is your 3-step action plan if you ever face retaliation. Number 1, document everything immediately. I mean, dates, times, witnesses, the whole shebang. Number 2, keep personal copies of all your hazard reports and safety communications. And number 3, do not wait around. File promptly online at OSHA.gov before your 30-day or 180-day window closes. I want to leave you with this final provocative thought. Will your safety culture survive the next unreported hazard? True EHS compliance doesn't come from fear, right? It depends on a fearless reporting culture where workers are empowered and protected by 29 CFR Part 24. A healthy reporting culture saves lives, and for sure, it saves companies from catastrophic liability. Thank you for joining me for this explainer. Like, share, and subscribe to HSE Study for more high-impact safety insights. Stay safe out there.